Well, welcome to this exciting event. I'd like to start by acknowledging the traditional owners of the lands on which we meet and paying my respects to the elders past and present of the Ngunnawal and Ngambri peoples. My name is Jeremy Farrall. I'm Associate Dean for Research at the ANU College of Law, and it's my great pleasure to welcome you to this exciting event with Justice Michael Kirby, the Honourable Michael Kirby, who will be sharing his experiences as chairperson of the United Nations Commission of Inquiry on Human Rights in North Korea. In a moment, I'll hand over to Professor Richard Rowe to welcome our special guest. But let me first say a few things about how this event will run. In this in-conversation event, Richard and I will take turns in posing questions to Justice Kirby. Once our conversation has reached a natural endpoint, we'll then open up for questions from the floor. This session is being recorded via Zoom for the LLB JD course, International Dispute Resolution. And so we would encourage you, if you have a question, to write your question in the chat function through Zoom, and then we will put them to Justice Kirby at the end of our conversation. A note also that Justice Kirby is proposing to post the video recording on his website. And so I just want you to be aware that your comments, your questions may well be recorded and broadcast more broadly than just in this course. Now, I'll hand over to Richard to introduce our special guest. Thank you, Richard.
Good afternoon, everyone. On behalf of all students, Jeremy and myself, it's a great pleasure to warmly welcome and introduce the Honourable Michael Kirby AC, who is our special guest this afternoon. Michael, we are really honoured that you've agreed to engage in this conversation with us in relation to international dispute resolution in practice, particularly with reference to the United Nations Commission of Inquiry on Human Rights in North Korea, which you chaired from 2013 to 2014. Students, of course, are very much aware of the very significant contribution you have made throughout your long career to the law in Australia and internationally, and particularly through the 13 years when you were a judge on the High Court of Australia from 1996 to 2009. But of course, you were so actively involved in the law before you became a judge on the High Court and made an enormous contribution in many areas of the law in that regard. Since you retired, you have actually been super active, I know, in so many other fields, particularly in relation to human rights issues, serving on national and international bodies, including those associated with the United Nations. You have also maintained and established very strong relationships with universities around Australia. And in relation to this university, the Australian National University, of course, the ANU College of Law holds annually the Kirby Lecture on International Law, which it was established in recognition of your passion for and service to international law. And it is without doubt one of the most significant events on the legal calendar in Australia. So we are really looking forward to engaging in conversation with you this afternoon. And I would like to ask the students to welcome you in what has become the traditional virtual way. And perhaps if I could start with the first question by asking you, how did you actually become involved in the Commission inquiry?
First of all, I'd like to thank Professor Rowe and Professor Farrall for having organised this event. And I'm always very happy to be engaged with the Australian National University and its College of Law. And I also acknowledge the Indigenous people of our continental country right across this mighty land, remembering how many wrongs have been done to the Indigenous people, which still remain to be cured. I was first approached about the Commission of Inquiry on North Korea in, I think it was in about March or April of 2013. I was actually at a conference in England of statisticians, very clever people, statisticians, and I got this call to ring my office and to make contact with my PA, and she told me that the High Commissioner for Human Rights at the time, Navi Pillay, a judge from South Africa, had inquired as to whether I would be available. A step before that was that in the 1990s, I had been the recipient of a special mandate from the United Nations, then Human Rights Commission, to be involved with the issues of human rights in Cambodia. And that was the first engagement I had with the UN at that level. And when I was invited by Navi Pillay to take on this role, I accepted, and I made contact with the Office of the High Commissioner, and we arranged that I would come to Geneva in July, and our first meeting of the three commissioners, the first of them was the former Attorney General of Indonesia, Marzuki Darusman. The second was the former head of human rights issues in Serbia, Sonja Basurko, and myself. And so we three became the commission. We had our first meeting in July of 2013. We had to get our report written by the end of 2013 so that it could be delivered to the Human Rights Council, as the commission had now become. And we delivered our report on St. Patrick's Day, the 17th of March 2014, in Geneva to the Human Rights Council of the United Nations. It was unanimous, it was on time, and it was brought in within budget. So that is how I got involved, and that is what we did. We agreed on our methodology, and we followed that through, and we delivered our report promptly, and on everything of substance, we were unanimous. No room for the great dissenter on this inquiry.
Well, thank you for that insight into how you became involved. We're just wondering what you saw as the biggest challenges during either the initial period when you were setting up or throughout the process, and then follow-up as well. What, if you had to name, say, 2 or 3 challenges that were the greatest, what were they?
I think the first challenge was that we knew we would not be given access to North Korea. Normally, if you're inquiring into the state of human rights in a jurisdiction, the logical thing would be to go there and make investigations and ask questions. But we knew that the technique of North Korea engaging with the United Nations was to avoid direct engagement and to forbid it. They had since 2004, when the special rapporteur on North Korea was appointed, they had refused to allow him to have access to their country. So that was the first and major problem. In the end, we overcame that because there are about 30,000 people who have fled from North Korea and who are living in South Korea. And when we were appointed, we put advertisements out, and we let them know that we were in the business and we wanted to hear from them. And we were then flooded with people who wanted to come forward and tell their stories. And so that was the first major problem. A second problem was of a legal character, and it was whether the material we had, awful though it was, of the conduct of the government of and administration in North Korea, raised itself to the level of genocide. And for that purpose of answering that, we went to the Genocide Convention of 1948. The Genocide Convention of 1948 says that the crime of genocide, the international crime of genocide, involves acts of violence done by a state agency and others, and on the ground of race, ethnicity, nationality, or religion. If you think of those four reasons, they grow out of the Holocaust and the then recently discovered terrible crimes of the Nazis. But the problem with North Korea was that the awful crimes which were revealed in the investigation which we conducted were not on the ground of the nationality or race or ethnicity of the victims, but were generally on the grounds of their political beliefs or suspected political beliefs. And so we, in the end, unanimously concluded that the gold standard crime of UN inquiries, genocide, had not been established, and therefore we held in that way. I think it's very important for UN inquiries to be truthful and to conform to the rule of law. You don't stretch the rule of law to say that something is genocide if it doesn't fit within the definition. There were some people who were a bit critical of our decision on that, but I'm pretty sure that that was the correct approach to take. And anyway, it's what we did. And so that was our finding in our report. The third problem was a methodological problem, and that was how did we gather the evidence? The Anglo-American system of inquiry is to have public hearings. It's just the way we do inquiries. You can think of the inquiry, the Royal Commission on Banking by Justice Hayne, the Royal Commission on Child Sexual Abuse by Justice McClellan. We sit in public, we allow the people to come forward. That, as it were, carries the community that's affected by the process of inquiry. This is not the way the civilian system does it. They tend to do things in private, in secret, and they just don't really buy the common law technique of public transparency. And my two colleagues, one was from Indonesia, who followed the Netherlands criminal code and civil procedure, and the other was from Serbia, who follow the similar, the German criminal code, and so they might have been opposed to it, but I persuaded them that with North Korea, the problem was transparency, and that it was therefore important for us to be transparent ourselves, and that this would be an antidote to the extreme secrecy of the Hermit Kingdom, as it's called. And so that was agreed, and that is what we did. We had public hearings. public hearings in Seoul, public hearings in Tokyo, in London, in Washington, and we also had a hearing in Bangkok, Thailand. And they were the public hearings on which we built the evidence, which became the foundation of the report of the Commission. This is the report of the Commission. It's not a huge document. If I can say so, it's very well written. And one of the reasons for that was that I, a natural English speaker, took responsibility for every word. UN reports are often a bit opaque because often they're written by people who are very brilliant and much better in writing than I am in French or German, which are my subjects at school. But getting a natural speaker in one of the UN languages to write and proof the report makes it much more readable. And if it's readable, it hopefully will have an impact on the audience, which is the member states of the United Nations.
Perhaps if I could just ask a follow-up question. Michael, I was very interested to hear you say there's this contrast between the civil law traditions of inquiry and the common law traditions. And I'm wondering, given that there is quite a history of UN commissions of inquiry, whether the Secretariat advised you in terms of what some of the traditional approaches have been in other commissions of inquiry, or whether you had full discretion to work out exactly what approach you wanted to follow.
Well, it comes as a shock to law students in Australia to learn that their precious common law system is not the predominant system of the world. In fact, it's the system in operation in about a quarter of the world, and the 3/4 of them follow the Napoleonic French system, which is a system that is much more congenial to authority and efficiency. Our system is not quite as efficient because it takes time to do things in public, but it tends to have merits of its own. The UN tried to. The senior officer said, well, we haven't done this. You'll have people who will be disturbing the hearings. You'll have people who don't want to give evidence in public, but may otherwise give evidence. These are horrible crimes that are being suggested. Don't you think it would be wiser to do it the normal way, behind closed doors? And I said, no, it would not be wiser to do it the normal way, because this is a country behind closed doors. We've got to do it openly. And my colleagues were very strongly supportive of that. And I think the experience indicates that it was the best thing to do, because when North Korea subsequently said, well, what do you expect? You call for submissions and you get all these enemies of the fatherland, they're going to be antagonistic. And I said, well, you can go to the internet, you can look at the testimony, you can make your own conclusions, and if you don't believe them, well, you can say so and give reasons. But the testimony was very compelling. Nothing like the actual words of a person who is a victim, to speak directly to power. And throughout our report, on every second page of our report, in dealing with the 9-point mandate that we had from the United Nations Human Rights Council, there are quotes from testimony. That's how you write a report of a Royal Commission. And that is a very powerful way of illustrating what people are on about, what they're complaining about. And so we said, well, you won't let us in. We've gone out to the witnesses. They say this. If you dispute it, let us in. And if you can establish that we have not been given the truth, we will be the first to correct it. But of course, they didn't let us in. They just attacked from the side.
Richard, your turn.
A question on methodology. So I think it might be of interest to the students to know in a practical way how you functioned on a daily basis. Did you have planning meetings in the morning? Did you have your support staff tasked, or were they making initiatives in proposing various action that might be taken? I just think in a methodological way it might be of interest to hear just how it functioned, the Commission functioned in its different parts.
That's a good question, because, you know, the honour and the glory of it goes to the commissioners, but behind the commissioners is the secretariat that works to the Commission. And they respect the fact that the responsibility for the findings and conclusions lie with the commissioners, but they have a plan, and they have the mandate, and the mandate has the 9 points of inquiry, and they have to try and get testimony that will cover all of the 9 points of the inquiry, and they would come forward and suggest this witness or that witness. And so the testimony was arranged, and we had an excellent secretariat. I mean, people are forever going on and complaining about the UN. President Trump did so recently in respect of the World Health Organization, and he may or may not have a complaint there, I don't know. But these people were very devoted, were very hardworking. They were independent of the UN. Their duty was to the Commission of Inquiry. Their duty was also to protect any witness whose public disclosure of their complaint could endanger the lives or safety of people who are still in North Korea. So all of this was gone through, and the Secretariat officers were extremely diligent and hardworking. They prepared, in most cases, first drafts of the findings of the Commission, and gave them to us. But that was then examined by the 3 commissioners. I went through every word, being an obsessive type of character who was used to writing my own matters in the High Court. I went through everything. I abbreviated some of the excessive length. And I did something which in the High Court and in the Court of Appeal, I often insisted on: say what you are finding. Or sometimes trial judges don't say, I find. And that makes it easier if you've got the list of the findings, because then you can measure the findings against the mandate. And so where it was uncertain, I inserted we find, or the Commission finds, and this is throughout the report, and it gives a sharpness, clarity, and focus of the report on the mandate which we have from the United Nations Human Rights Council, and provides the basis on which we are asserting that serious offences against international human rights law, and in the case of many of them, crimes against humanity, have been established by the testimony, which is online and which can still be seen. If people want to have a look at the testimony, it's still up there. You can't get it in North Korea, but you can get it just about everywhere else.
Thank you.
Michael, we're interested to push you a little bit further on the findings, which you've just mentioned, actually. So you've noted the position on genocide. I was just wondering if there were any other controversial elements. From memory, there was an issue relating to freedom of religion. Is that?
Well, there were elements that were controversial. One of them was religious freedom. It was suggested that the fact that religious freedom was so repressed in North Korea that this was evidence of genocide. One of the submissions was the census that had been conducted in North Korea just before or in the very beginning of the DPRK, Democratic People's Republic of Korea, had shown that the Christian population of North Korea was about the same as the percentage of the Christian population to this day in South Korea. It's about 22%. But the latest census had revealed that the Christian population in North Korea was something like 2%. And therefore, the suggestion was that we would draw the inference that the difference of 20 odd percent had been destroyed, had been murdered or removed. And that was put forward as a basis of finding genocide, because you'll remember the last ground in genocide is on the ground of religion. So that was an issue we had to resolve. And we had people coming forward saying that the reason religion was discriminated against in North Korea was the Marxist principle that religion is the opiate of the people, and that therefore the people have to be saved from this opiate. But the United Nations principles in the ICCPR, in the Universal Declaration of Human Rights, and one of the 4 freedoms mentioned by President Roosevelt in announcing the Allied war aims before all the human rights law was developed, was the right to worship God in the manner which you choose. So all of this had to be weighed up by us, but we concluded that it may be that some religious people have suffered in North Korea, and maybe even some have been killed for their religious beliefs. But we were not convinced that the evidence of the difference in the statistics was sufficient to make the very serious finding that they had been killed because of their religion, and therefore we didn't make it, and therefore we did not find the gold standard crime of genocide. Some people think if a COI of the United Nations doesn't find genocide, this is somehow a bit of a failure on the part of somebody in the system. But there were plenty of crimes against humanity that we found. And the point we made was a point that is made by many writers, scholars in this area, that crimes against humanity are themselves very serious international crimes. The definition of a crime against humanity is that it must be a crime of violence, and that it affects a lot of people, and but it's one that shocks the conscience of humanity. That's the test: shock the conscience of humanity. So it's not just an ordinary daily human rights abuse, because every country has human rights abuses. We in Australia have 1 or 2 of them in respect of refugees, for example, or Aboriginals, for example. But to be a crime against humanity, it has to shock the conscience of humanity. And if you find that, that is already a very serious finding. And that is what we found. And on that basis, we recommended that the relevant leaders in command in North Korea should be referred to a prosecutor of the International Criminal Court, with a view to consideration of the prosecutorial discretion as to whether they should be brought before the ICC, the International Criminal Court, on a mandate given by the Security Council. North Korea is not a member of the Rome Treaty, as Australia is, but there is a way in which you can have the matter referred to the International Criminal Court, and that is if the Security Council decides to do so. That was what we recommended, but that step was not taken, not at least to this stage.
Thank you for those comments. In answer to Jeremy's question, I was going to follow up on the question about what action has occurred in the UN context in relation to the report and recommendations.
Well, many steps have been taken. The report of the Commission of Inquiry was referred to the Human Rights Council, where it was delivered. The Human Rights Council, by a very large majority, accepted the report and followed up what we said should be done to it. They then referred it to the General Assembly. This is when North Korea really began to take the inquiry very seriously, because the thought of their supreme leader being brought before the International Criminal Court was a matter of great concern to them. And therefore they opposed that, and then they started to lobby very heavily against anything being done. But the General Assembly, again by a very large vote, these were exceptional and most unusual votes, referred the matter to the Security Council. Now that is very unusual in the UN system, because generally the body which is charged with the peace and security of the world doesn't get involved in human rights issues, because human rights issues are often extremely divisive and political. But the matter was referred to the Security Council. It was added to the agenda of the Security Council. You'll remember that under the Charter of the United Nations, there are 5 permanent members of the Security Council, the P5, and they have what has been called a veto to stop anything that they disagree with being passed by the Security Council. However, there's a little known provision in the Charter, which provision makes an exception to that power, and this is that in the event of a procedural motion, the veto doesn't apply. And so China and the Russian Federation opposed the matter being placed on the agenda of the Security Council. However, the requisite supermajority, we in fact got 11 of the 15 members. 2, China and the Russian Federation were against. 2, Nigeria and I think Chad abstained, and all the other members of the Security Council, including the Western P5, voted to put it on the agenda. And that is where it remains to this day. But interestingly, in December 2019, when the agenda item would ordinarily be considered again, the United States of America and the Republic of Korea, which was a non-permanent member of the Security Council, did not vote in favor. I say that's interesting because they would normally have been supporters of the matter being raised on the agenda of the United Nations, but the Trump administration gave instructions, and the United States did not vote in favour, and so it was lost and was not raised in December 2019, which was, in my respectful opinion, a very unfortunate step. And it's also unfortunate that the Republic of Korea did not, in the General Assembly, vote in favour of the resolution to condemn human rights abuses in North Korea. So that is something that didn't happen back in 2012, 2013, but it shows that times change, administrations change, different attitudes arise. The other thing that the United Nations did was to accept one of our recommendations, which was to set up in Seoul, in the Republic of Korea, a field office, as it's called. That is to say, an office of the United Nations High Commissioner for Human Rights, which continues the work of the Commission of Inquiry, continues to gather the testimony of people who have fled from North Korea to South Korea and who want to come forward and tell their stories and have the matter recorded. It's a very strange thing how people who have suffered terrible crimes have this very deep feeling that they must not leave this planet without having put their experiences on the record. And even if nothing else was achieved from the work of the Commission of Inquiry, that's a very important achievement, in my opinion.
Well, thank you, Michael. I think I might, for this in-conversation part of the session, I might ask one final question, and then I'll open up for questions from everyone else. And I would encourage you, if you have a question to ask, please put it in the chat function, and then we will pose it to Justice Kirby. So the final question I have, and it's one really, it's seeking your advice for everyone in this course and everyone who's still a student at university who might have an interest in doing this sort of work and engaging in commissions of inquiry. What advice would you have for students who do have an interest in undertaking this sort of work? What sorts of skills and expertise should they acquire?
Well, I want to ask you a question, Professor Farrall, because when I was just winding down from the work of the Commission of Inquiry, I thought, I know what will be my most popular article in a law review ever. And it will be, how do you get into United Nations human rights work? And so I started to go around the Palais des Nations in Geneva and to speak to all the Australians who are there. The place is riddled with Australians. We are not seen as threatening, and we are seen as competent and professional. And so there are plenty of Australians, and I just went through their careers. And the answer that I give you to your question is basically you've got to get into the system. If you get into the system, then if you're any good, you'll be judged on your merits, and you will be seen, and you'll be given chances. You'll be pushed forward. But if you never get into the system, it's very hard to make headway unless you've got a bit of governmental or other backing. But so that's what happened to most of them. Many of them went to Geneva and worked on the smell of an oil rag as UN volunteers. Now, Geneva is probably the most expensive city for the UN in the world. It has, in the Economist Index of Big Mac, Geneva is the most expensive Big Mac in the world. And it therefore is not an easy place to go without a bit of cash in your pocket. But if you can get in and then get noticed by the NGO representatives or by the United Nations representatives, and you can get a chance and get into them, then your career can take off. And there are people there, including one of my associates in the Court of Appeal days, who are really top people in the Office of the High Commissioner for Human Rights, simply because they got in and then they worked their way up in the system. Now, I've got this question for you. If I write that article up, I've got all the notes and all the papers. Will you publish it in the Federal Law Review?
Well, I'm not on the editorial board for the Federal Law Review, but I would certainly strongly recommend to my colleagues that it would be
encouragement.
a terrific article to publish, yes. We also have the Australian Yearbook of International Law, so there might be interest from the editorial board there. I'm sure any of our journals would be delighted to publish any of your article ideas.
Could I just also mention in the context of, let's say, involvement and direct experience with human rights and Human Rights Council, is that the Australian permanent mission to the United Nations in Geneva has an internship program when the Human Rights Council is actually in session. And some students already from the ANU College of Law have been selected as interns and have gone to Geneva in previous years. And that's a very, I think, very useful way and in a very concentrated form for any of you students that are interested to get that direct experience to apply for an internship. So I'd encourage you to do that. Yes, the information is available on the website of the Australian Permanent Mission to the UN.
Our mission in Geneva is particularly talented, and the ambassadors tend to be very fine diplomats, but also they're very interested in the way the UN operates and in multilateral operations. And it's curious that this year has been the first year, I think, that Australia has been a member of the Human Rights Council. But even if you're not a member of the council, you can take an active part and interest in the work of the council. But I agree, that would be a great way to get in, but that will just be 1 or 2 slots. Whereas if you're looking for something where you can take an initiative and get in there, there are other routes but you've got to have enough money to survive in Geneva for, say, 6 months or even 12 months and hang around the Palais des Nations and get involved with the activities of the Human Rights Council and other UN bodies there. And one thing can lead to another. I think the way I got into these things in the very beginning was I got involved in student politics. And I was a real troublemaker in universities. And I used to chair the Law Society and then the SRC and then the Union and then the National Union of Australian University Students. And I became a very good chairman. I'm still a good chairman. I was a very good chairman for the Commission of Inquiry. And so if you display your talent as a chair, that's another good thing, because that can help you getting other opportunities. People say, oh, yes, there's that judge from Australia. What's his name again? And that leads on to your getting calls to do another job for the United Nations. And that's what happened in my life.
Well, Michael, we have a number of questions that have been typed up in the chat function. Are you familiar with the chat function on Zoom meetings?
Yes.
If you click on the chat bubble at the bottom.
Short questions and short answers. Okay. Now, the first question, are you optimistic about the continued survival and relevance of the UN in the current? Well, I certainly am. I mean, the current international situation shows what a crisis we face when we don't have the international and multilateral organizations. It's true that it appears that there was a delay in China notifying the World Health Organization. But they notified the World Health Organization on the last day of 2019 that an epidemic had broken out in Wuhan. Or it appeared to be that there's serious health problem. And the very first thing that anybody knew about it was sometime late in November. So we're talking about a delay of about 6 weeks. It's not a hanging matter. And in the end, China, of course, we know, took very important steps and protective of its population. And Helen Clark, the former Prime Minister of New Zealand and former head of UNDP, is heading the inquiry, and we'll hear that in due course. But where would we be if we didn't have the World Health Organization, or UNAIDS, or UNDP, or all the other UN bodies, or for that matter, the Security Council and the General Assembly? So, yes, I'm optimistic. From Justin, when you assessed DPRK human rights, did you need to adjust the standards in line with the societal context? Well, the principle of universal human rights is that you don't say, oh, well, they're just poor, ignorant, religious and culturally backward people, and therefore we can't expect them to meet the standards of human rights. If, in fact, the standards of human rights are too severe, then maybe they need to be adjusted for a standard that applies to the whole world. That's a different type of argument. But we tried, the Russian ambassador actually gave very good advice to me when I first met him. He said, we know the comrades, we know what they're going through. We went through all this ourselves. If they ever do something that is good, give them credit. And they did sign the convention on disabled persons. So we gave them credit. But there were precious small pickings to give credit for, but the adjustment has to have limits. Otherwise, you say, "Oh well, poor ignorant Asian people, we don't hold them to the same standards." Well, the universal human rights do hold us all to the fundamental basic principles. And our job as human beings is to try to make sure that that works. Jonathan, so many horrific stories told to the Commission. What was the worst testimony? Well, I think the worst testimony was the case of the woman who had a baby while she was in detention being repatriated to China. And she was told by the North Korean guards, you have to drown that baby. That baby is from Han Chinese. The baby is not a pure Korean. So drown the baby in the bucket. This is what was said. And the woman, when she gave the testimony, broke down. We all believed that what she was saying was true. There is certainly racial discrimination in every country, and I think in North Korea. And it was a very strange thing, as somebody who'd been a judge for 34 years in Australia, to be sitting in this inquiry, listening to the most horrendous crimes against humanity and crimes against international human rights law. And I sometimes felt that I was like one of the judges at Nuremberg, or one of the judges in the post-war investigations of the Nazis. There's no doubt North Korea is not in the league of the Nazis. They don't have a sort of factory line to exterminate people. But the best chapter in the report of the Commission of Inquiry is the one on food. And it's about the starvation of people in North Korea and how they're spending all their money on a huge army, the third largest army in the world, and on nuclear weapons, and not on feeding their population. So they're just a few of the. Can I take some more questions?
Yes, please
All
do.
right. I'm getting quite good at this Zoom stuff.
It's very impressive.
Whoever would have thought that a former justice of the High Court would become a Zoom maniac? Jacob, people sometimes get jaded about UN bodies and their effectiveness. What do you think is the impact of the Human Rights Council in addressing human rights and abuses regarding North Korea or other cases? Well, they can't put an army in the field and force North Korea. It would be too dangerous. North Korea now has nuclear weapons. So that's not a strategy that would work. But I think it can be said that North Korea didn't like having its human rights record on the agenda all the time. And we put it on the agenda. And I think the fact that our report and the public hearings and the internet testimony was very powerful. And they were just about to come up to their second tranche of Universal Periodic Review. And so they didn't like having all this attack. And they were very, very deeply concerned about the letter I wrote to them, warning them that the Supreme Leader might, under the command principle in international law, be referred to the International Criminal Court. So there are things you can do. And the interesting thing is I think as a result of the report of the Commission of Inquiry, when the question arose whether the Security Council should vote extra and additional sanctions against North Korea, the Security Council did vote them twice. And the People's Republic of China and the Russian Federation voted for them. They are concerned about the condition in North Korea. They were concerned about the findings in our report. They didn't like some of what we found, but they are neighbors. They have a border with North Korea, and they would be naturally very concerned about the possible outflow of huge numbers of the population. So don't tell me that you can never have an impact. You can have an impact. And none of us should just wash our hands and say, oh, well, this is just too difficult. We're not going to do it. Well, I think the fact is that it had a lot of impact, and the impact is continuing. In fact, it hasn't really yet fully begun. Angelique asks, since such commissions in their own right were prestigious international experts, if there were any obstacles or legal disagreements, how did your role as the appointed chair assist in the common understanding? Well, I'd been a judge for 34 years. I'd been a judge in appellate courts for 25 years. I knew from my experience that you have chief justices, but they can't bully their fellow judges, and it's quite wrong for them to do it. They generally don't try. So that was the last thing I was going to do, to try to bully my colleagues. I just explained my point of view, and we ultimately reached agreement. If we hadn't, I would have respected fully their entitlement as experienced human rights commissioners to record and explain their differing view. But as it happened, we didn't have any such differences. And this is an important thing to keep in mind when you hear about my role in the High Court and being described as the great dissenter. I'm not just a curmudgeonly person who disagrees with people on principle. In the Law Reform Commission and in the work in Cambodia, the work in North Korea, my work in all the UN agencies, I didn't dissent, and we reached agreement all the time. So that really is an indication of what an agreeable person I am. From Jeremy Farrall, do you have any questions for Justice Kirby? Well, does anybody else have any questions that they haven't yet put on the chat line?
I think there are still two on the chat line.
All right,
Michael,
okay.
there's one from Hayley Keane towards the top there, I think. That I'm not
Which
sure
one is this one?
So it's just below Angelique's question.
Okay, I'll go to Angelique. Here it is. Hayley, I have to follow up question on interviewing survivors. Important part of what is required of commissions in interviewing vulnerable groups and ensure the safety of witnesses and the integrity of their testimony? Well, that is a very important question. And in fact, there's a very good article in the Adelaide Law Review. It's about 2 years ago, which I wrote with Rebecca Lafargia, who is a teacher in international law at the University of Adelaide. And it's about this very question. How can you be sure you're being told the truth? And of course, this is something in my long years as a judge I also had to confront. But there are various ways that you can scrutinize the testimony, and you can scrutinize it where, for example, you have testimony that there is a detention camp for people who are detained because they're thought to be enemies of the people. And unfortunately for North Korea nowadays, there are satellite images of North Korea down to very fine, you can see the blades of grass. And likewise, Google Earth can take you down into anywhere on the Earth's surface. And therefore, the places which people described could be checked up. And sometimes people who did not apparently know each other could give testimony about the same camp and describe how the layout of the camp, the watch towers, the arrangements that they had, and so on. So there are the usual techniques that are used by decision makers. The consistency of the testimony, consistency within the testimony of one witness and with other witnesses, and the whether the story given is given in a way that appears to be convincing, though here you have to be a bit careful because there's a lot of evidence that says convincing witnesses may not necessarily be telling the truth. However, you can't dance on the head of a pin against the possibility that you're going to get somebody who's going to tell you a lie. You have to do your very best to make findings, and that is what we did. And we went through the testimony and we explained what people said. We quoted the essence of what they said. It's in the report, and ultimately we could fall back on the principle that they had denied to allow the United Nations, of which they are a member, to come in and investigate offences against the International Covenant on Civil and Political Rights, of which they are a member. And if that is the case, then it makes the fact that they won't let you in rather telling, I think, that the testimony just could be right and probably is, and we thought was. And anyway, if you've got a doubt, you can Google Commission of Inquiry on North Korea and you can find the testimony and reach your own conclusions on it. This is why it was very important in the case of such a secretive country to jump the border, to use the satellite images, and to use the testimony which is online on the internet for the whole world to see. And I think that's why China and the Russian Federation ultimately voted to increase the sanctions, because that was what was required in it's a wonderful thing to be in that big room, the big room of the Security Council. You've seen it on the telly. It's got the horseshoe table, and on the wall is a magnificent tapestry. I think it's probably a Gobelin. And here there are 15 human beings. They are the members of the Security Council, representing the 5 permanents and the 10 non-permanent. And they have enormous responsibility for our species, for our survival. And it's amazing how when that happens, when you've got that responsibility, it doesn't always work, but often there will be a finding of commonalities that people can work together. And we're seeing this in COVID-19. We're seeing people are cooperating because they can see it's in the interests of the human species and of our survival on Earth. And with nuclear weapons, including in the hands of a country like North Korea, which is a worry, and is a human rights issue in itself, there is a need for cooperation amongst us all.
Well, Michael Kirby, I think it's time for us to draw this session to a close, as reluctant as we all are to do that. You mentioned a moment ago that some people might consider you to be a curmudgeon. None of us here certainly consider you to be at all curmudgeonly. You've been an inspiration.
I didn't mention any names. I wasn't thinking of the lake, across the lake and the building on the other side.
You've been an inspiration to generations of law students, and we're so grateful to you for giving up so generously of your time and sharing your experiences. You're an inspiration, not just in terms of what you've achieved in the law in Australia, but also on the international arena and towards the cause of human rights. And we so value your time with us and the insights that you've shared today. And what I will do now, if we were in person, Richard and I would present you with a bottle of Australia's best wine. We'll have to wait to some point in the future when we can deliver that by hand. But what I might ask everyone to do, I'm going to unmute everyone's microphones and I'll ask everyone to express their appreciation in the traditional form. Thank you so much.
Thank you.
Thank you very much.
Thank you.
Thank you very much, and I'll do it again.